Hey everybody, this is Charlie Dobbins, and this is the next live group coaching call for the Multifamily Investing Academy's Masterclass Elite program and the Owner Forum program. So just as an update, if anybody has any questions, you can just type them into the question box down at the bottom. I will be either answering them now or later on. I'll catch up with you and make sure that you get the right answers. So, but also what we're going to be talking about today is kind of a follow-up to our last group coaching call, because last time we actually used a particular student's documents that he was working on, and I don't want to post that call on the group coaching call archives because it contains some personal information. So we are not using that that particular presentation. I'm redoing it right now. It's actually, I think you're going to enjoy this. You're going to learn a ton in today's call, stuff that you never knew existed or you never knew how these things operated. And after today's call, you will know, you'll be so much more knowledgeable about it that you can expect things. You'll be able to anticipate problems that would creep up in your multifamily business. Keep in mind, folks, the whole point here is to help you build a multifamily business. And as the business owner, you've got to understand all facets of the business. And one of the things, the most important thing, has to do with the mortgage documents. Because many times while you're running your business, you're going to be thinking to yourself, how does this particular event impact my relationship with my lender? And all of it is spelled out very nicely in the mortgage documents. Now, what we're looking at here, I'm calling it the multifamily mortgage documents, but I'm specifically using Fannie Mae's documents because they are the standard. Now, if you are, you're going to take this lesson and be ready to deal with Fannie Mae, but as if you go to a local lender, you're going to be taking this information and applying it to their documents. So I want to give you first the 30,000-foot view and then kind of bring it down to different levels. So, and I'll tell you something, I've done deals with Fannie Mae, I've done deals with, what I like to call Fred's Bank, which is your local, mom and pop bank. And the documents do have major differences between the two. I mean, believe me, the banks write these things so that they are protected, but Fannie Mae writes these things so that you can't even squirrel out of them if you wanted to. I think that sometimes some of the local lenders have documents that are just, not as tightly written. They don't have the requirements in there. Like, for the perfect example, reserve replacements. We talk about them all the time. They are virtually, and I'm not saying absolutely, but they are virtually always required on a Fannie Mae deal. But I did a deal with a local bank where they said, oh no, you escrow for the reserves and you escrow for the taxes. And that's how they did it. So there's one glaring difference between Fannie Mae and somebody else. So those are the types of things I want you to keep in mind. Now, as we proceed, I always start off these calls by saying, as required by the Massachusetts Bar Counsel's office, I'm here to inform you that I am a lawyer. I'm not your lawyer, so get a lawyer, okay? Don't think, I help my clients out as best I can, but I cannot represent you. I do not take on that mantle of being your counsel. I will work with your local counsel, but I'm not going to represent you in any way as an attorney. Okay, so let me just do a quick little jump over here because it's going to kick me out, but let's move over here to the documents. The first document we're going to look at is the multifamily note. Everything starts right here, folks. This is the beginning of the transaction with your lender. The lender, the note is a document that says, I'm going to give you X number of dollars, and you have to pay it back under these terms. It doesn't have any security interest to it. It is just a note that says, I owe you, essentially. So when you hear things talking about, well, the mortgage, I have a mortgage on my house. Well, what you really have is a note on your house that is secured by the house as collateral, and the document that ties the note to the collateral is the mortgage. So when you get the mortgage released, you get the note released. So, but everything starts with the note. If there's no lending going on here, then there's nothing to secure. So this document, what I've done here is all of these documents in the form that you see with the highlighted sections that we're going to talk about are going to be posted on the group coaching call archives along with this video and in their entirety. But for the sake of this discussion, I've just gone and created an abridged version of these documents so that we don't have to scroll through 52 pages of of text that I'm not going to talk about. So we're going to do the abridged version here during the video. Now, as you can see, this is the controlling paragraph, the controlling phrase. For value received, the undersigned, the borrower, promises to pay to the order of the lender the principal amount of $1 million, together with interest thereon accruing at the interest rate on the unpaid principal balance from the date of the mortgage loan proceeds are dispersed. That's it. That's what the note is all about. The borrower is going to pay the lender this amount of money with interest as stipulated in this document. Now, as security, look at here. What they do here is they now start to tie together other documents. So you can't have this note by itself without having the security instrument, the loan agreement, and any other loan documents the bank wants to have from you. All of those documents are now hereby made a part of this particular note, and if there's a discrepancy between any of them, the loan agreement shall govern. And you'll see what the loan agreement looks like, and you'll understand why it governs. It essentially is the Bible of the relationship. It is the rule book for the relationship. It determines exactly who does what and who owes whom what. Okay? Now, one thing, I'm going to show you some things here. I want you to understand how all these documents tie together. Look at paragraph 4. It talks about two things. It talks about the event of default. Notice that it's capitalized. That means it's a defined term. And it talks about the default rate. Well, what are those things? What are they? Let me tell you, folks, you had better know what they are. And it's defined here in the definition section. But you, as the owner of your business, had better understand when you sign your name on this document, you are obligating yourself to perform a certain way. And if your performance results in an event of default, what happens? And what constitutes an event of default? You better know that, because what happens is if you trigger an event of default, that what they're saying here is we can accelerate the note. Oh man, they can come and foreclose? Yes, they can. Well, what's an event of default? Well, let's read about it. So make sure you understand when you see these defined terms, make sure you go back and you check it out. Now check this out. Hold on, I want to show you something. Okay, personal liability. Remember, we talk about recourse and non-recourse, and I hate recourse. I love non-recourse. I try to tell all my students, don't get into a recourse loan. You don't want to do it. You can't sleep at night when you're on a recourse loan. Trust me, guys, this is personal experience speaking. And so what you want to do is you want to make sure that when you sign up with Fannie Mae, you get a recourse loan. I'm sorry, a non-recourse loan. That's what you're looking for. Okay, but look at here. It talks about personal liability. The provisions of Article 3 of the loan agreement are hereby incorporated by reference into this note to the same extent with the same force as is fully set forth herein. Now, this personal liability, I thought my mortgage broker told me I was getting a non-recourse loan. I better read this section and understand what they're talking about, right? Okay, So then we scroll on down, and let me find what else. Okay, now check this out. I love this. Waiver of trial by jury. So in case they decide they're going to sue you for damages of any kind, this document, way back when you first got involved with working with this bank, Fannie Mae, they got you to agree to waive a jury trial. Now, at the time that you agreed to that, it probably didn't seem like all that much. But now you're getting sued by Fannie Mae because you did something wrong. And they're going to go right before a judge. Your right to a jury trial has been expunged. Now, just ask yourself something. Why does this matter so much to Fannie Mae that they put it right in the very first document in all caps? Why is that? Well, the fact is that Fannie Mae is not looked upon very nicely over the last couple of years. And they know that most juries don't like them. So the last thing they want to do is have to argue their case before 12 of their peers, so to speak, who've probably been involved badly or been, had some involvement with the mortgage debacle back in 2008. So they get you to agree to no jury trial. I just wanted to share that with you, just so you understand a little bit of the color of these documents. Okay, next. So then we have the note, but let's go talk about that one particular document that is the governing document, the loan agreement. Here it is right here. It's called a multifamily loan and security agreement, and I chose to show you the non-recourse version. Now, just so you understand, let me show you. Let me get this for you. Let's see, Fannie Mae right here. Folks, all of the documents that I'm showing you right now, I downloaded from the Fannie Mae website. They are all public documents. Anyone can get their hands on them. Okay, so if you really want to see how this operates or what other types of documents are out there, you can just come to this website right here and you can find it very, very easily. Okay, so just remember that none of this is hidden. You shouldn't be surprised by any of it. And if you're going for a closing on a multifamily deal with Fannie Mae, don't be surprised at the closing table by the documents and what they say. Do your homework ahead of time and make sure that all these documents are put together correctly and that you understand how each one of them works. And if you don't understand, call me. I mean, if you're a student of mine, that's what I'm here for. I will walk you through the documents so you understand how they operate. Okay, so this one's a non-recourse. Folks, take a look at the table of contents. This breaks everything down. This shows you exactly what is involved in all of the inner workings. Look at personal liability. I see default rate up there. I see acceleration of mortgage loan. I see all these things we talked about that should scare the daylight out of most people, but they're not going to scare you because you're going to understand how they all work. All right, so here are all everything that's included. Now, do you see why I call this the handbook? I call this the rule book of the deal, the Bible of the deal. Look at this. We're up to 83 pages, and look at the last one, all in caps, waiver of trial by jury. They just don't want to appear before any citizens of the United States. It's kind of shameful that that's what our government requires. And this is it's a GSE, a government-sponsored entity. Okay, then they have the schedule and exhibits. Now, all of these schedules, the only one that I'm going to touch upon very briefly is Schedule 1 because it's the definition schedule. So the way it works is each one of these documents has a separate schedule. You can go on to that website and pull down exactly what these schedules look like. We're not going through 7 schedules. We're only going to go through a few definitions in Schedule 1 just so you can see what they mean, how they're drafted, and where they can be found. Okay? So scroll on down. Multifamily loan, here it is, non-recourse. I want you guys to really focus on that non-recourse because I'm going to show you something in a moment that might scare you a little bit, okay? So as you can see, I highlighted right there where it says the definitions schedule is attached as Schedule 1. So if you're looking for, like for instance, the events of default or the default rate, what are those definitions? You're not going to find them in the loan agreement. You're going to find them in the Schedule 1 of the loan agreement. So just understand how these documents are all put together. Okay, protective advances. Understand what a protective advance is. All right, because this is not a good thing. It's a good thing for the lender. It's not a good thing for you. Now, just take a look at it. As provided in the security instrument, lender may take such actions or disperse such funds as the lender reasonably deems necessary to perform the obligations of the borrower under this loan agreement and the other loan documents, and to protect the lender's interest in the mortgage property. Oh, that's nice. Oh, that's so swell of them. But what does that really mean? That means that if your property is not doing well and it's an all bills paid property, you're responsible for the utilities, and you don't have the money to pay the utilities, and the utility company is standing at the door ready to shut you off, and you call your lender and said, hey, I can't make the mortgage this month because I got to pay the utilities. They will say, we are going to issue a protective advance. We are going to pay the utilities. And once we do, we're taking the property back. We don't think you can run it. We're taking the property back. Or if there's a foreclosure, or the taxing jurisdiction is foreclosing on you because you can't pay the taxes, they will issue a protective advance and then take the property. Okay? So understand protective advances are there to protect the lender, not to protect you. If you ever find yourself in that situation, I'm telling you folks, just drop the keys on the bank's desk and wish them all the best, and be thankful that you've done everything right, including taking a non-recourse loan. Okay? So that's what protective advances mean. Scrolling on through, here's the default rate. Okay? The default interest rate shall be paid if any amount due in respect of the mortgage is more than 30 days past due, or if the indebtedness is not paid in full on the maturity date. Okay, well, what is the default rate then? How much do I pay? Well, you got to wait for the definition section, and I'll shock you. All right? So just understand, this is how, remember, it's a template document, so they can modify the schedules a lot easier than they can modify the template. So what they do is they stick the actual definition of the default rate down at the very end. Right here, all they're telling you is when your default rate is going to be triggered. And this isn't the only time that it gets triggered too. So just keep in mind, we're going to come back to that in just a moment. Now, check out, here it is. Remember this whole thing about prepayment. Or you hear defeasance, you hear prepayment penalty, all these types of things. It depends upon what type of loan you're buying. What happens here is that the bank will hit you hard, and very hard, in the event that you want to prepay the loan. That's why the person wants you to assume the existing loan, because they don't want to have to pay that penalty. They want to transfer it to you. What nice guys. So understand how this works. The borrower shall not make a voluntary full or partial prepayment on the mortgage loan during any prepayment lockout period, nor shall the borrower make a voluntary partial payment at any time, except as expressly provided in this loan agreement. A prepayment premium calculated in accordance with the prepayment premium schedule shall be payable in connection with any prepayment of the mortgage loan. Think about that, folks. What kind of bank doesn't want their money back? Maybe a bank that isn't really a bank. See, because you're not really borrowing this money, though you technically are. You're actually, it's coming to you in the form of a securitization. It's coming to you in the form of a security. In other words, Grandma has bought a bond, and Grandma is expecting that bond to last 10 years and pay her a particular interest rate. And guess where that bond is coming from, the money from that bond? It's coming from you, from your mortgage. And if you pay that mortgage back sooner, grandma is going to have to do something with her note, with her bond. She's not going to get that money over the next 10 years. That's how these things work. So that's why you see these big, huge penalties. So, borrower further acknowledges that lender is not required to accept a voluntary prepayment of the mortgage loan on any day other than listen to this one. This is very interesting. And this comes in when you're buying the property or you're closing on the property, because what happens here is the person, the owner, has to contact the lender and gets a payoff amount, and then they have to close within, I think it's 5 days. It says it right here, within a certain number of days. And if they miss that day, if you can't close in that day, you gotta wait another month. So that's one of the problems with these types of loans. You can only close on certain days, and if you miss it, you got to wait for the next month. Kind of a pain, but that's how these things operate. Just so you understand how a Fannie Mae deal typically works. Now, if you're dealing with Fred's Bank is going to want their money back as fast as you can. So when you're dealing with Fred's Bank, you want to negotiate with Fred and say, listen, Fred, I don't want to have any prepayment penalty on my loan. Oh, hey, no problem. You want to pay it back sooner? We'll take it. We'll take your money and go put it back to work somewhere else with some other lender. See, Fred's Bank acts like a bank. Fannie Mae acts like a security salesperson. Okay? Now, understand, and that they explain it to you here. And the reason why they explain it to you here is they don't want to have any problems down the road with litigation. They want to make sure that you understand what you're signing and why you can't prepay this note sooner. They explain that if you prepaid it, it could result in the lender incurring loss, including reinvestment loss, additional risk, expense, and frustration or impairment of a lender's ability to meet its commitments to grandma. Doesn't say grandma, it says third parties, but I want you to know that the third parties means grandma. It is extremely difficult and impractical to ascertain the extent of such loss. The formula for calculating the prepayment premium represents a reasonable estimate, and the provisions regarding the prepayment premium contained in this loan are a material part of the consideration of the mortgage loan. It's a consideration, meaning that the reason why we're making this a non-recourse loan is because you are agreeing not to prepay it sooner. Okay? So you see, that's the connection. We'll give you this, but you have to give us that. And there's a consideration right there for it. All right. Now, before we get into the really fun part, let me just check for any questions. Let's see if we check for any questions. And then, of course, I can never remember how to check for questions. There we go. Good. No questions, because you guys are all so smart. All right. Good. Now here's the fun part. Remember, look at right down here. Look at down here. It's a non-recourse loan. It says it on every single page. It says it right there in the footer. But then we come to Article 3, and it's a personal liability section. Well, wait a minute. It says non-recourse. There's a whole section on personal liability. Folks, this is the most important section of all of the documents that we're looking at today. You need to understand exactly how these documents work. So let's take a look at this. Section 3.01, non-recourse mortgage. Except as otherwise provided in this article, in any other loan document, none of the borrower shall have personal liability under this loan agreement or any other loan agreement for the repayment of indebtedness, and the lender's only recourse for the satisfaction of such indebtedness and the performance of such obligations shall be the lender's exercise of its rights and remedies with respect to the mortgage property and any other collateral held by the lender as security for the indebtedness. This limitation on borrower's liability shall not limit or impair lender's enforcement of its rights against guarantor under any loan document. Okay, let's take a look here at the operative terms. Look at the very beginning. Except as otherwise provided. Remember, two things I learned in law school. there's an exception to every rule except for one. This rule, they accept it right at the very beginning, except as otherwise provided, because there will be exceptions to this thing that says you will owe nothing personally, except, and then they're going to tell you about it in just a moment. So what they're saying is, well, we'll call it a non-recourse loan. But you know what? Truthfully, this is a partial non-recourse loan or a partial recourse loan. In other words, if you do certain things, you will owe us money. Well, what are those things? Well, we'll get to them in a moment. So, the borrower shall be what are those things? Here they are, right here. Look at, they're all spelled out for you very, very nicely. Let's take each one by one so that you understand this. And remember what I said at the very beginning. Remember what I said at the very beginning. You are looking to start a multifamily real estate management business. That business is managed by you. You have to manage to all of your obligations that when you sign your name on the dotted line, you are obligating your business to do these certain things. And you have to make sure when you're making decisions by asking yourself the question, will this decision impact my loan with my lender, impact the loan obligations with my lender? Here are the things you need to keep in mind. You shall be personally liable to the lender for the repayment of the portion of the indebtedness equal to any loss or damage suffered by the lender. Remember, folks, it's not just the amount of the mortgage. It could be more, because they're going to whack you with legal fees and costs and protective advances, and you name it, they'll hit you for it. So it could end up being a lot more if you fail to pay all the rents when the lender, because remember, they're not your rents. They're not your rents. When you sign these documents, you sign an assignment of rents to the lender, where you are saying, okay, I will collect all the rents, but they're really yours. I'll give them to you. And in these documents, what the lender then does is he says, okay, you know what? You and I are friends, and we're getting along really nicely. So I'm going to let you keep all the rents, and just keep the property in good condition. Keep doing what you're doing, and as long as you do that, you get to keep the rents, and you get to keep the profits from the rents. And I'm not going to take anything. But if you screw up, if you create an event of default, if you don't do any of the things that we've listed here, then what's going to happen is I'm going to take those rents. I'm going to notify you and say, hey, you're in an event of default. You're in a default situation. Give me my rents. And all of a sudden, overnight, the money that you were collecting from that property, the property management fee that you were paying yourself, goes out the window. And all of that cash, all the tenants are notified that they have to send their money to a lockbox, and you never see a dime. So this is what Fannie Mae could do to you if you don't run the property the right way. And so if you don't give them the rents, you could be personally liable. If you don't turn over all the security deposits, you could be personally liable. If you fail to maintain the insurance policies on the property, you could be personally liable. If you have an insurance claim and they pay you the money and you don't fix the property, you put the money in your pocket, you could be personally liable. If you don't keep good books and turn them over to Fannie Mae when Fannie Mae asks for them, you could be personally liable. If you waste or if you abandon the property, they're coming after you. Forget the non-recourse. You are personally liable. If you do things that are grossly negligent or reckless, unintentional material misrepresentation or omissions, if you're essentially committing fraud, you are personally liable. So just understand, under those circumstances, this non-recourse ability could go away. Now remember, this is called Article 3 personal obligations. Now think about it for a second. In this particular document, it's calling you the borrower. Okay, fine, you're the borrower. What happens if the borrower is ABC Investments 1 2 LLC? That's the borrower. And guess what? You know, we signed on the dotted line, ABC borrower, and they are just they're broke. They don't have any money. They shut down their doors and take the property back. And they did one of these things that triggered the recourse. Can the bank come after ABC Investments LLC as the borrower? Yes. Is it going to get anything? No. Do you think the bank has figured that out and has another way to get around that? And the answer is yes. And you'll see how they do that in just a moment. Okay? It's like a soap opera here, the way I set these questions up. Okay. Now, full personal liability. Now, folks, let me just tell you something. Personal experience. I've been in a situation where we've had to give a property back to Fannie Mae. And it was a non-recourse. And they never came after us because we did everything we were supposed to do. We really managed that property to the letter of the document. And if we were getting ourselves into trouble, we were on the phone with our lender. It was a DUS lender, a delegated underwriter and designated underwriter and servicer. And we did everything we were supposed to do. And we didn't get in any trouble. Thank you very much. Didn't work out. You go your way, we go our way. And they didn't come after us personally because we didn't violate the terms. I say that because I have some friends who just received a letter from Fannie Mae saying that Fannie Mae is coming after them for a violation of these terms, of these provisions. They are waiving the non-recourse and they're coming after them personally for what they have. I don't know the hard, cold facts of the situation. I just know that these are super people, and I don't know what happened or why they're doing it. Now, listen, hey, I've been involved with the government myself, and I know that these people sue for the wrong reasons, and they usually lose. But they make your life miserable in the meantime. So remember, you're running a business. Above all else, you are building a business that's going to withstand the test of time, and you've got to do it right. Do not cut corners. Do not think to yourself, oh, they'll never find out. Oh, don't tell them this. No, that's not the way to run a business. Let people know. And if you know how your business is being run, let your lender know. They're your biggest partner in the deal, okay? So let me see here. Now, full personal liability for mortgage. Mortgage loans shall be fully recourse to the borrower upon the occurrence of any of the following. Okay, failure by borrower to comply with the single asset entity requirements. I'm going to show you that later on, what exactly that means. It's very simple, and it's not something you can you should ever have to be concerned with breaking. A transfer of the property to another entity that is not permitted. Bankruptcy by one of the borrowers. Fraud, written material misrepresentation or material omission by one of the key people involved in the deal. Fraud, written intentional material misrepresentation or intentional omission by any of these other folks in connection with the ongoing financial or other reporting required. So, one is fraud in the, what we say, I'm not going to say fraud in the inducement or fraud in the contract, but what we're saying here is fraud when you applied for the loan or fraud when you're continually supplying them with the documents. And I tell you something, folks, that's you heard me talking a couple of group coaching calls past there with my accountant and how things move so smoothly. I'm telling you, when you report your financials to your bank every single month and you know that they're right and you know that they're done by a CPA and everything is perfectly in line, man, it makes your life so much easier. That's a great way to run your business. So here are the things that you'll be fully responsible for. Now, this gets to the single purpose entity. You're going to create an entity that is just your company. And this one company, all they do is own this property. They don't go out and enter into any other contracts with other properties. Set up another entity for that. But Fannie Mae wants it to be one party. They don't want to have to be tied to any other deals going on. It's as simple as that. So this is how you always want to make sure that this is one thing you need to comply with regarding the Fannie Mae deals. All right. Okay. Borrower single asset status. This, the borrower, ABC, Investments LLC, does not own or lease any real property or assets other than the mortgage property, does not own, operate, or participate in any business other than the leasing of this one mortgage property. As you can see, this is what a single asset status, and they don't want you to breach this. If you breach it, it could be a reason that they're going to come after you for full recourse. Don't do it. Oh, and this is something else. Now, there's restrictions on distributions. Now, of course, as an LLC, we talk about distributions. Here, what we're saying is no distributions or dividends of any nature with respect to the rents or other income from the mortgage property shall be made to any person having a direct ownership interest in the borrower if an event of default has occurred and is continuing. Now remember, we haven't even got to the definition of events of default yet, but boy, they keep creeping up in this document as something that we really need to manage to. So we need to make sure that we understand what's an event of default. And I'm telling you, folks, if you pay your investors when you have an event of default going on the property, you could be held personally liable. So make sure you understand that and you manage the deal properly. Okay, scrolling. From and after the effective date, each property manager and each property management agreement must be approved by the lender. All right. You hear it talked about it a lot that, well, if I'm going to get a Fannie Mae, I need an approved property manager. Yeah, you do. Get an approved property manager. And then, when you're ready to start managing the property yourself, you notify the Fannie Mae that you're going to be the property management company. Happens all the time. Borrower shall pay to the lender upon demand all rents after an event of default has occurred and is continuing. And then borrower shall not interfere with the lender's collection of rents. Now, let me tell you what this means. Just so you can get let me take what this contract terminology and apply it on a day-to-day basis, so you have a better understanding of what this means. If you have an event of default and the bank steps in there and says, "Hey, we are activating the assignment of rents, and we will collect all the rents." And so they go around to all of the tenants and they say, and they post in the door. Every tenant gets a letter that says, "From now on, you are going to pay your rent here, and not where you have been paying it. Don't walk into the office anymore and pay it. You must pay it to this bank." And so all of a sudden, your cash flow is gone. And that ticks you off. Oh, the bank can't do that. How dare they? I need that money. I need that money to pay these bills. They can't just do that. I mean, they can keep the money and then give it back to me, but this is not the way I want to run my business. So then you go around and you notify all the tenants. Don't worry about that letter. Just keep bringing your rent into our office and we'll take it. And then you take that money and you go deposit it into your account. That is a huge no-no. You got to deal with your bank. You got to work it out with them. They don't want to be in this situation as much as you don't want to be in this situation. Figure out what went wrong on the property and fix it. But don't do anything that's going to circumvent the bank and their collection of rents when they've accepted, when they activated the assignment. Okay? You get yourself into big trouble. Big trouble. I'd much rather watch that rent walk out the door than have the bank activate the recourse provision, and I have to pay all of the losses on that property. Okay, financial information. This tells you what they want to see. And when you are so proactive that you give these guys what they want on a regular basis, I mean, the way it works with me is my accountant automatically emails the monthly reports right to the bank, and I don't even have to worry about it. It's part of my deal with him. It's not a bad way to run your business. Okay, and that way, if things are going wrong on the property, as they sometimes do, then guess what? They can't say they didn't know. They've been getting the financials consistently every single month, emailed to them. So hey, you can't complain, guys. They will, but sorry for them. Okay, so this has to do with the insurance. This basically says borrower acknowledges that any failure of borrower to comply with the requirements set forth in this section above shall permit lender to purchase the applicable insurance at borrower's cost. Now understand what this means. This is if you don't have insurance on the property, they will put what's called forced place insurance on your property to make sure that they're protected. And any claims coming off that forced place insurance goes to them. And listen, that means that they're going to start charging you the premium on the policy and then some, like an administration fee. They're going to whack you with both. So what happens in that case is obviously now you got an insurance premium that's far higher than what you were expected. But folks, this is how I've seen it happen. I've seen it happen this way before. What happens is you got a big claim on your property, and you can't find a renewal that's good. You're getting killed on the insurance, and you can't afford to buy the insurance. Well, guess what? They're going to do a forced place insurance policy on you and start to pay. You're going to have to pay. Well, hot dog, at least I've got some type of insurance protection because I couldn't find any. Nobody would insure my property. You go on their blanket policy and you get the protection. Might not be what you want, might not be, the payee who it should be, the insured should be, but at least you're not, if the place burns down, you're going to have coverage. So I've seen that happen as well on some of these. Now, in the event of loss, I'm not going to dip into this. This talks about insurance. And that talks more about insurance, liens, transfers, and assumptions. Folks, take a look at this. Now, for some of you, this might not register with you yet, but for those of you that have been making offers on assumptions, and you see my letter of intent for assumptions, and you see the provisions that I put in there to protect you against all the ways you can be screwed on an assumption, here's the document that will prove to you why we say what we say in those letters of intent. Okay, so here's the first thing. Other than a transfer to which lender has consented, borrower shall not transfer or cause to be transferred any direct or indirect ownership interest in the borrower, key principal, or guarantor if such transfer would cause a change in control. So in other words, don't try to sell someone your limited liability company in a way of trying to get around an assumption fee or what have you. If you're selling more than 20% of your company, then guess what? That's a transfer, and you have to notify the lender. Okay? So just keep that in mind as well. A direct or indirect restricted ownership interest in the borrower, key principal, or a guarantor of 50% or more of key principals or guarantors' direct or indirect ownership interest in the borrower that existed on the effective date. All right. So it also goes on to say about the 20% rule. For anybody with more than 20%, you have to notify them. So in other words, you can't transfer the property but not really transfer the property. I've seen this happen so many times, and people think it's, oh, what a great idea. I'm not buying the property. I'm buying the limited liability company that owns the property. That way, we don't have to tell the bank, and I don't have to qualify. And I have bad credit, so therefore, I'm going to be okay. Don't do it. You're trying to pull a fast one on Fannie Mae, the king and queen of fast ones. You're going to lose every single time. So just keep that in mind as you're going through this. Don't try to pull a fast one with Fannie Mae. They're smarter than you are. Okay, no mezzanine financing or preferred equity. Neither the borrower nor any direct or indirect owner of the borrower shall incur any mezzanine debt or other permitted mezzanine debt, issue any preferred equity or other type of permitted preferred equity, or incur any similar indebtedness or issue any similar equity, okay? This gets to the seller financing, or it could get to the seller financing. It depends upon how your capital stack is being structured. But if the seller offers you seller financing and they say, okay, yeah, sure, that's fine, we can do it, and you're assuming their note, and then it turns out that you can't do it because this provision's in there, well, it's not your problem. That's a seller's problem. He's got to figure out a way to get you that seller financing that's not going to violate the terms of the agreement. Because the last thing you're going to do is assume an existing mortgage from this guy and automatically be in a situation where you've got an event of default. Just don't do it. But the thing is, if you've structured it so that it's not called a second mortgage or it's just seller financing, now the burden is on the seller to come up with a solution. And he might have to just reduce the price of the property if he can't come up with a solution. But it's his problem, not yours. So make sure you structure the deal that way so you don't have that problem. Okay, lender shall consent to a transfer of the mortgage property to and an assumption of the mortgage loan by a new borrower if each of the following conditions is satisfied prior to the transfer. And this lists all the things that have to happen. You know, you submit the documents. There's no ongoing event of default. The new borrower slips into the shoes of the existing borrower, is equal to or greater than the existing borrower, and that gets satisfied. None of the people who are borrowing are prohibited persons. The entity that's buying doesn't have a stale date on the structure or the ownership of the entity that will be before the maturity date of the note, and they also have to execute the assumption agreement. They have to take care of any title claim issues or title company issues. They have to do an endorsement to the title policy, and then the lender has reviewed and approved the transaction documents, and the lender, of course, has received their assumption fee of 1%. Typically is what it is. Okay, fine, all well and good. Very simple, just like doing a new mortgage, right? It's just as simple as that. We're just assuming this note, and we're going to take on the existing obligations free and clear. Simple, right? Easy. Well, let's keep reading. Let me scroll down here. All right, this has to do with a death. Unless waived in writing, shall replace. Okay, if somebody dies, if one of the guarantors dies, one of the key principals dies, you have 180 days to find a new one. Make sure you work very closely with your lender to let them know you're trying to solve that problem, and you haven't come up. You know, if you can't do it, they do extensions, but you don't. You know, that's a tough situation, folks. I'm telling you, that happened to me. That happened to me. A lender died. I mean, the borrower died, and we had to come up with a solution. We ended up having to sell the property. But keep that in mind, okay? I'm not telling you to go get physicals on all your key principles, but, you know, just have everybody understand that this is what happens when, you know, if somebody should pass away. Further conditions to the transfer and assumption. In connection with any transfer of the mortgage property, any ownership interest in the borrower, key principal, or guarantor, blah, 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 lender may, as a condition to any such approval, remember, read this, lender may, as a condition of any such approval, require additional collateral, additional guarantees, or other credit support to mitigate any risks concerning the proposed transferee or the performance or condition of the mortgage property. Right there. Do you remember what the provision we put in the letter of intent and then subsequent purchase and sale agreement to protect ourselves against the bank from doing this? Because think about it. We bought this property. We took a look at the deal. We decided that if we have to put $500,000 down on this property, we're going to get a 20% cash on cash return. And all of our investors have come into the deal expecting a 20% cash on cash return. And then the bank looks at this provision and says, you know, we don't really like you guys all that much. We'll make it happen for you, but we want a little bit more security. Okay, what do you want? We want you to put $500,000 in our bank. That'll make us feel better. Well, no, that would mean that I'm not getting a 20% cash on cash return. I'm only getting a 10% cash on cash return. You've just doubled my obligation. Yeah, well, That's the deal. Take it or leave it. And by this time, when the bank finally tells you this, they don't care that your money's gone hard. They don't care that your earnest money is hard. They'll walk away from the deal as fast as you will. But you'll have to leave your earnest money on the table. And that's why we put that provision in our letter of intent, and that gets transferred to the purchase and sale agreement. And that's why the property, oops, what do we have here? I'm not going to, yeah, that would be bad if I, yeah, let's do it late. You guys are seeing how the sausage is made in the company. Okay. So this is why you always want to make sure that you have that provision in there for an assumption, so the bank, if they pull this fast one on you, you're protected. Okay? All right, how we doing? Wow, we're running out of time. Imposition in the event of default, and an imposition are your reserve replacements. Simple as that. It's your reserve replacements, and it's also any tax, withholdings for tax, property taxes, or insurance escrows, tax escrows and insurance escrows, and it's also the reserve replacement escrows, and so they call those collectively the impositions. So if the imposition, if you're in an event of default, the bank can keep that money and use it as they see fit. Sorry, I just had imposition. I was thinking about the Inquisition. And okay, Mel Brooks's Inquisition. Okay, upon payment in full of all sums secured by the security instrument. Oh, this is very important. This particular paragraph goes to that other section in our letter of intent that we put in there for an assumption. Because remember how we talk about the reserve replacement. What happens to the reserve replacement at the closing table of an assumption? Let's say the seller has never touched his reserve replacement and there's $100,000 in there. What happens at the closing table for that $100,000? It's right here. Upon payment in full of all sums secured by the security instrument and this loan agreement and released by the lender of the lien of the security instrument, lender shall disperse to the borrower the balance of any imposition deposits then on deposit with the lender. Now remember, it's a new borrower. So one borrower is being released and a new one is stepping to the plate. So the old borrower, once he gets released, he gets that money. And the new borrower has to step in and fill the bank, replace that missing money. And that's you. And if the guy left $100,000 in the bank and he's walking with it, that means you've got to come up with $100,000 to put into the bank. Well, wait a minute. I never agreed to that. If I had got a new deal, I wouldn't have to put up that money. Well, that's why we write it into the purchase and sale agreement so that this doesn't happen. All right. Okay. I'm actually going to looks like I'm just going to have time to get through this one particular loan and security agreement. I will post oh, actually, you know what? I do have to jump through this. I do have to finish this. I should be able to finish this. Okay. Okay. Look at this one. Conditions to disbursement. This is very important. Lender may. Look how it starts off. The lender may, but the lender's not obligated to. The lender doesn't have to. The lender may require any of the following at the expense of the borrower as a condition to disbursement of the funds. Okay? Here's why it says may. The lender could be one of 20 different lenders. Now, what do you mean, Charlie? I thought we were talking about Fannie Mae. Right, we're talking about Fannie Mae. And Fannie Mae has what's called what are called DUS lenders, delegated underwriting and servicers. They're the ones that really deal with you, that act with you. Fannie Mae doesn't have any contact with you directly. They have these other minions out there. And all of these other companies set their companies up differently as long as they comply with the Fannie Mae guidelines. So when it comes to a reserve replacement disbursement, all of these different minions can do it differently, because Fannie Mae says lender may do it this way, or they may not. So what this means to you is you want to work with a DUS lender who is very borrower friendly. Because I'm telling you, when you're owning a property and you have to get something fixed on the property, you want to make sure that the bank is there as your friend and will work with you towards using the reserve replacements to getting the deal done. I've worked with two particular dust lenders. One was a nightmare. They're no longer in business, and presumably we all know why. The other one was phenomenal. I'll tell you right now, the phenomenal company is a company called Walker Dunlop. They were so easy to work with, and they just understood what it was like to own and operate a property. Whereas this other company that's no longer in business made it so hard to get your own money back after you fixed up the property. So these are the types of things that you want to investigate before you get in bed with a particular Fannie Mae dust lender, because they're all going to give you your money back, but they all can do it under different circumstances. And that's the thing you want to make sure that you understand. All right, let me just check for questions, because I know we're coming up on the hour. Oh, let's see. Good. Nobody had any questions. Hot dog. All right. As we scroll through it some more. Yeah, there it is. Lender May. Once again, Lender May. Okay, defaults, remedies. Okay. Here are the events of defaults. Automatic events of defaults. Any failure to pay a deposit when any amount required by this note, that's an event of default. Any borrower, any failure of the borrower to maintain insurance coverage. I'm not going to go fraud, negligence, commencement of a forfeiture action or other similar proceedings. It goes on and on. 11 different events of default and some with subsections. Okay, these documents will be on the student on the group coaching call, and you can go through each of them. You have to understand what the events of defaults are. All right. Now, the thing about the events of default, what happens? What can the bank do to you if you have an event of default? They can accelerate your loan. They can call your note. That's, those are all, foreclose, accelerate the note, call your loan. Those are all one and the same thing, essentially. Make sure that you understand that. And man, I tell you, when you get that phone call, the bank's not happy. They're going to call your note. Man, that's not good. It's not a good position to be in. Loss of right to disbursements from the collateral accounts. You can't take the taxes out. You can't take the reserve replacements out. You can't fix up the property. They're holding your money. These are the things that happen. And then they could enter into a forbearance agreement where you structure a deal with them where they say, okay, listen, we're not going to take your property, but you got to perform this way. You got to put up more collateral, and we got to do this, and you got to maintain that. And if you do this for a certain period of time, we'll remove the forbearance agreement. And that's how these things operate. Okay. But keep in mind, if they enter into a forbearance agreement, they're not waiving any of their rights. They can still foreclose on you. Don't give them a reason to. Work hard, work with them. They're your friends. It's tough to say, but they are. Okay, so that's the document. All right, perfect. Let me just jump on over here to the note. Okay, there's one thing I'm going to show you in the. Here are all of the. Here are all of the definitions, okay? There's a borrower or affiliate. There's a 20% provision. I just want to show you right here, folks, default rate. This is all I'm going to show you right here. This will be posted on the website. Check this out. What's the default rate? If you enter into an event of default, what happens to your payments? The sum of the interest rate plus 4 percentage points. Ouch! If your interest rate right now is at 4%, your payment almost doubled in a month because you are now in a situation where you are in an event of default, and that triggers the default interest rate, and it goes up by 4%. Holy cow! That is huge. That is huge. If you think you had trouble making your mortgage payment before the event of default, you're in an even worse situation now. fix that event of default, get out of that situation, and so you don't have to pay that default interest rate. Okay? All right. The other document I'm going to wrap up on, going to come in right at 1 o'clock, is this one. This is what throws people for a loop. Okay? Remember, if you look at the loan agreement document, the party that we're talking about here is the borrower. But remember I told you before, well, what happens if the borrower is ABC Investments LLC and the borrower goes belly up and there's no money in there, and now they have triggered a situation where it's no longer non-recourse, it's now recourse. What happens then? Does the lender now, how can the lender get his money back? Because they're not going to be able to get it back from the LLC. It's empty. Well, what Fannie Mae, in their infinite wisdom, has done is they have made those key principals and all those other people become guarantors. So when you look at this, in the first blush, you might think to yourself, well, wait a minute, it's non-recourse, but now I have to sign a personal guarantee? How does that work? So much for it being non-recourse. Well, the fact is that it is not only, this guarantee is only for the losses that Fannie Mae incurs as a result of your breaching of those non-recourse provisions. If you committed fraud and they take the property back and have lost money, remember, it's no longer non-recourse, and now they can come after you personally because you signed a guarantee. Okay, so this guarantee document is one of the documents you're going to be signing at the closing table, and this document is what's going to, keep you up at night. So just manage your business the right way, and that's what you always want to do anyway. Manage your business the right way, and you will love it. It'll be the greatest business in the world. You try cutting corners, you try, sticking your head in the sand, any business will be a nightmare for you. Don't be that guy. Run your business the right way, okay? So, I don't think I didn't take a sip of water. I didn't even come up for air. I got more to go over, but I'm not going to put you all through that because I just hit the 1 hour mark, and I really like to keep this thing down to 1 hour. This document, all the documents, I'm going to start to produce the video right away. Watch for an email from MFIA saying that the masterclass group coaching call has been posted to the archive, and you can go back and check it out. Hope this was helpful. It's got some good stuff in here, and if anybody has any questions, you all know how to get a hold of me, and I will talk to you all later.